Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I like to talk about employee status and the first resignation. As a labor attorney, I'm handling many labor cases, especially sometimes I'm requested to represent the company and terminate the employment contract with the Korean branch manager for the certain employer. So in that case, when I received such a request for terminating a Korean branch manager, I always judge the case based on whether the Korean branch manager is employee or employer. So Korean branch manager is employee, then company must show some justifiable reason for termination, or else the company must prepare a lot of money for peaceful settlement for this forced resignation. On the other hand, if the Korean branch manager is employer, then it is easy to fire the Korean branch manager. Just in this first resignation, then employer may suggest maybe 3 months additional salary for this peaceful settlement process, because employer cannot be protected by Korean labor law. So they are only protected by the civil law. Then unless there are certain special protection articles in the employment, maybe service contract, they cannot request or cannot apply for any remedy to the labor commission. Only they can apply to the civil court. But civil court, they deal with the case based on party A and party B. So in this relation, there are no protection at all for Korean branch manager. So my role is to judge whether the Korean branch manager is employee or employer, based on their job characteristic. Like registration as an employer in Korea is a secondary the factor I judge, but I judge the case based on the like a personal supervision from the head office, or whether they have authority to control their own business, like working hours, working time, or operation. Secondly, what they earn from the company is a fixed salary, or just mostly is based on incentive pay. So when they receive the fixed salary, usually it is like they are working as an employee. But most important part is whether Korean branch as a special autonomous authority to control Korean branch office, like in financial view, and also some HR view or operational view. So they are fully in charge of the people, or in charge of operation, and in charge of some limited financial control. Then usually we classify them as an employer. But the other one, they are anytime when they decide, before they decide to do something, they have to report and get permission from regional head office or head office. Then we regarded them as an employee. Yeah. So based on then, we visit the company and explain to them and their legal right. Then we suggest, usually good Korean branch manager is not easy to fire, because there should be justifiable reason if they are they have employee status. But the other one, they violate company regulation seriously. Then we explained some reason. This process. Also, the company need to prepare some settlement money, because they have employee status. But if Korean branch manager has employee status, then it's a different one. Company may suggest some small amount of severance package rather than big amount, because they have been working as the employer So okay, for the explanation, I'm going to attach with this video with my article. Thank you for watching. Bye bye.